It happens. During the past 10 years that I've been representing people charged with shoplifting, I've heard many stories about how someone made a mistake. They were shopping at a store, they purchased a number of items and accidentally walked out of the store with something they didn't pay for. A loss prevention officer grabbed them as they were leaving the store and accused them of petty theft. It's a crime of dishonesty punishable by jail time. The person explained that it was a mistake, but nevertheless they were taken into a back room, interrogated, called a liar, held for hours, and forced to sign documents. And then a law enforcement officer arrives on the scene and either makes an arrest or issues a notice to appear. Even in those cases in which the law enforcement officer has some doubt about whether the person is guilty or not, they make the arrest and they figure, well, the courts will sort it out later. In many of these cases I see, the person with the false accusation of shoplifting has never been in trouble for anything in their entire life, and suddenly their life is turned upside down. My name is Leslie Sammis, and I'm a partner with the Sammis law firm in Tampa. I represent people charged with shoplifting and other types of theft cases throughout the Tampa Bay area and in all of the surrounding counties in Central Florida. Now, how do these false accusations occur? Well, I have a lot of sympathy for the loss prevention employees. They have a very difficult job. They deal with people every day who are guilty and beg for forgiveness. They deal with people who are guilty and claim not to be guilty. They deal with the organized career shoplifter with a long criminal history. And they are trying to protect their company from a very serious problem, shoplifting. It's their job to confront people and accuse them of shoplifting and to get a confession. Most of the time they get it right, but sometimes they make a mistake. And the problem is that the loss prevention officer has an incentive or a motive to make an accusation of shoplifting, even in a highly questionable case. These loss prevention officers know that after the accusation, the person arrested will get a letter called a civil demand letter, which tells them they have to pay $200 or they could be sued in civil court for damages. I'm going to tell you a little bit about the civil demand letter. Many of the large stores will, after they accuse somebody of shoplifting, after that accusation is made, the retail establishment will get all of the customers' contact information and then turn it over to a law firm that acts much like a collection agency. Even in those cases in which the merchandise is recovered and there's no actual damages incurred by the store, the law firm will send a letter to the customer demanding that they pay a civil penalty, which they say is authorized under Florida law, statute section 722.11. The civil penalty demand letter states that unless they pay a fee, usually $200, then the law firm could proceed a lawsuit to collect civil damages. The first letter vaguely implies that paying the requested amount will prevent any further litigation, and many people incorrectly assumes this means that no criminal prosecution will take place if they pay the requested amount, and that's not true. Regardless of whether you pay or not, you're still going to face the criminal charge. And if you don't pay, then you're going to get a second, even more threatening letter demanding a higher amount, usually $475. Now, there's a recent article in the Wall Street Journal that I've listed on my website that discusses this whole problem and how the retail establishments make millions of dollars sending out these letters, even though they never actually follow through with the threat. In fact, they never sue anyone. They just threaten to sue people, and it works. The problem with these civil demand letters is it gives the loss prevention employee an incentive or a motive to make a false accusation. I don't know exactly what this money is used for, but I imagine that it helps pay the salaries of the loss prevention employees. And this small, improper financial motive is a big reason that I believe some of these false accusations occur. Now, nobody feels sorry for the person who's guilty of shoplifting if they get a threatening letter and they end up paying money because they're scared. But the point is, it can lead to a false allegation because it creates this improper motive. These types of cases happen, and if you've been falsely accused of shoplifting and your case is in the Tampa Bay area or any of the surrounding counties, contact me to discuss your options if you want to fight a false allegation of shoplifting.